you are dismissed. We'll continue with the remainder of the panel. We'll now recognize the ranking member, Mr. Green.
Thank you, Mr. Chairman. We have now concluded that Dodd-Frank is not perfect. The current bankruptcy code is not perfect, but we can, it seems, make the bankruptcy code perfect, whereas we cannot make Dodd-Frank perfect. So let me start by asking, who among you would eliminate Dodd-Frank completely? If you would do so, would you kindly raise your hand? This way I'll be able to move quickly. Who would eliminate Dodd-Frank completely? Mr. Taylor, would you eliminate it completely? Mr. Taylor, I hate to do this because time is of the essence.
No, there's some things in there I would not eliminate.
Okay, so you'd keep some portions of Dodd-Frank. Mr. Rosner?
I would keep some portions.
You'd keep some portions of it.
And you clearly need an alternative. I would just note very quickly, I know you have very little time, is that many of the tweaks that we need to do to the bankruptcy code that are in all the recommendations actually make it more like Dodd-Frank in many ways to accomplish some of the goals. Bankruptcy needs cash because in a huge crisis, debtor in possession financing is not always available. So you got to find ways of doing that.
Into my next question, so let me just toss it to you. The Dodd-Frank mimics the bankruptcy code as much as possible, but it has some additional things that the bankruptcy code doesn't have. Can you take just a quick moment and give us some thoughts on those different things, please?
Well, a couple of things. First of all, it does have the orderly liquidation fund, as we've talked about a lot. The bankruptcy code would need cash in order to be able to do a resolution. If you're trying to deal with systemic risk, you need to have some ability to deal with systemic risk. And to say you want to eliminate any ability to make sure you can maintain operations, which does involve preferencing some creditors, I think is not consistent with trying to maintain deal with systemic risk. The bankruptcy code itself has some mechanisms to continue those things. They might need to be expanded. The ex ante, or the before decisions are made, decision by a judge on each of the questions, is something that Dodd-Frank puts after the fact for lawsuits to challenge what the receiver has done, and the receiver would need to be able to act quickly. That's one of the things that Title II does. And it also provides for broad authority to transfer things to that bridge financial company.
Thank you. I ask a question about Dodd-Frank and mending it because there are some people who want to end it, and there are some people who want to use your testimony to end Dodd-Frank and bring in a regime under bankruptcy. Let's point to something else. There was talk about the industry being taxed after the fact once the liquidation has taken place. That taxing, as you have called it, isn't that similar to the premium paid by banks with FDIC, Mr. Kriminger?
What is the difference, of course, is that the deposit insurance fund is funded up front by premiums paid, risk-based premiums. The order liquidation fund is repaid if all the cash that's paid, received through the bridge company could not repay Treasury, which I think is very unlikely. You'd have to almost have the value of that company being zeroed out because Treasury takes off the top. The cash is risk-based and it's paid ex ante, very much like the deposit insurance fund.
So the similar, it's just that one is paid up front and the other is paid after the fact, correct?
That's correct. An important difference, too, to respond to one of the questions noted earlier, is that this is only paid by those institutions that are over that $50 billion threshold or have been designated as SIFIs. It's not paid by the thrift and savings and loans that are smaller.
Now, Mr. Kriminger, in your document, your paper, by the way, I thought it was excellent. I plan to post it on my website. In your paper, you indicate that there's an additional thing that Dodd-Frank does that bankruptcy doesn't do. Dodd-Frank deals with creditor claims, whereas, bankruptcy deals with creditor claims, whereas Dodd-Frank also deals with protection of the public, and it looks at the impact on the economy. Can you please give some thoughts on this, because it's important for us to note that in '08, the crisis was so large that banks were not lending to each other, that a prepackaged bankruptcy was not possible because you didn't have the liquidity to take into that process. So with that in mind, would you kindly explain how this notion in Dodd-Frank of protecting the public becomes exceedingly important?
Well, it's really the reason that Title II was created in the first place was because of making sure that in that rare, extraordinary circumstance where you had a systemic crisis, that you had an additional option that could impose losses upon the shareholders and the creditors as much as possible, while making sure you could continue those operations of the institution that would deal with systemic risk. That's why you needed funding, and that's why inevitably, just as you do in bank failures, because of maximizing value, you do have some creditors who get more than others. To say that all creditors should get only the amount provided for under the priority system in some ways is not even true under bankruptcy at times because you need to continue operations.
One final quick question. How many of you would make the big banks smaller? There's been talk about doing it. Let's see now if you would do it. Would you make the big banks, would you downsize them, break them up? If so, kindly raise your hand. Okay, we have one person, Mr. Rosner Wood. All right, Mr.
So but you asked I would like to get rid of this too big to fail.
I understand, but
I
would
would
you,
like to
but the question I'm asking is, would you break up the big banks?
Those effects. That would have those. So they asked the question that way. You missed I think the point that we have a problem that's.
I understand the
implicit
point,
subsidies.
but when you make statements about breaking up the banks, I'd like to know if this is what you would do.
Well, when I say break up the
My
bank,
time has expired, and I've
Can I just
overstayed, so
clarify?
I have to yield back, Mr. Chairman.
Gentleman's
Yeah.
fine to answer the question.
So, to clarify, if the Fed took seriously its obligations under Title I, which would be to use the living will process to figure out how institutions can fit through the bankruptcy code, Title II becomes unnecessary. Would I use that process to achieve those ends? Yes. Is that forcibly breaking them up? No. It's creating incentives to make sure that they are manageable through the bankruptcy.
And in effect, what you're doing, what you're acknowledging is that Dodd-Frank provides the means by which this may be done.
I don't think so.
No, what I'm acknowledging is that there is a tool that creates a living will, which is a blueprint for how things could work, not will work.
Well, I didn't say how they will, but I do contend, and I believe you agree, that Dodd-Frank provides the means by which it may be done.
I appreciate the dialogue and debate.